This case had been sitting in court for years, until one question changed everything. Back in 2021, a man was arrested for driving while intoxicated. Police claimed he was swerving between lanes, had glassy eyes, smelled of alcohol, and failed multiple sobriety tests. His breath test came back at 0.15. It seemed like an open and shut case. But in March 2025, a new defense attorney stepped in, and she noticed something strange. "Judge, can we revisit probable cause on this case?" At first, it didn't seem like a big deal. The case was old. Everyone assumed probable cause had already been handled. But then she said something that changed the direction of the entire hearing. "I don't believe there was probable cause. At least not based on what I'm seeing." The courtroom paused. "You don't think there's probable cause?" Looking at the sworn report, no. That's when things got technical, but also critical. The arrest had to be justified by a sworn statement. Not assumptions, not later reports, only what was officially documented at the time. And according to her, that sworn report was missing something very important. There's no reason listed for the traffic stop. That one detail could make the entire arrest invalid. Because without a valid reason to stop the car, everything that followed could fall apart. The judge leaned in. Now he was looking at the same document. "So you're saying the sworn statement doesn't explain why the stop happened?" "Yes." The prosecution tried to rely on a more detailed report, one written after the arrest. But there was a problem. That report wasn't the official sworn document, and it could be updated later, which meant it couldn't be fully trusted for probable cause. The only thing that mattered was what was sworn under oath at the time, and that document was incomplete. The courtroom got quiet. After reviewing everything, the judge made his decision. "I'm going to find no probable cause in this case." Just like that, the case collapsed. But the judge wasn't finished. "You were given court orders, and you didn't follow them. That's unacceptable. My only concern is that you don't endanger people on the road." Then came the final warning. "I'm dismissing this now. But if you come back here again and don't follow the rules, it will not go well for you." "Yes, sir." And just like that, a years-old case was dismissed. But here's what makes this story important. Even when evidence seems strong, the law still requires one thing above all: proper procedure. Because if the foundation is flawed, the entire case can fall apart. And in this case, one missing detail changed everything.